if in a claim in the federal district court I reference two different orders, do I need to have them both up front, or can I wait for the one for the damages until after the 21 days is up and they don't respond?
Okay, say that one more time. You have two claims in the federal district court?
One claim with two orders. One would be a cease and desist order from further trespass until the claim is solved, and the other one would be for the damages. So my question is, I know I need the cease and desist order to go in with the summons and the initial claim, so it can be served to the wrongdoer respondent. Is it okay to wait for the damages order until the 21 days is up, or do I need to do it up at the same time as the first order?
Okay, this is kind of vague. I'm trying to catch on real quick. Hang on a second, Greg, before we jump in. I'm trying to figure this out. Are you the claimant? Are you the one making a claim? File the claim in the district court?
I'm the one making the claim.
Okay, and what is the claim basically about? What is it? What is the trespass? What did they do?
It's they're trying to take our home.
Okay, so what's the?
And so we are claiming we have ownership with actually 3 other court processes.
There has to be a trespass. What is the nature of the trespass? What's the characteristic of the trespass? When you wrote the caption, you wrote like the United States District Court of Central Missouri, whatever. You put your name and the other people's name on the left. Put those funny lines in the middle, and the captions on the right. You wrote a trespass. And you wrote colon. What is the characteristic of the trespass? How did you define the trespass?
Trespass upon claimant's rights, personal property, and land, and that's it.
So that's what you did. Well, okay, that's pretty long. How did you stylize it again on the front cover?
Declaration wrong, trespass upon claimant's rights, personal property, and land.
Wow.
And that's
okay. No, I'm just trying to say, I try to tell people to say you're administrating my property without right. You know, or just, just like administrating with property, I'm just trying to make it really simple. The administration of property without right. I kind of see where you're going with that. Okay, and did you go through the private process first? Did you exhaust all kinds of administration?
I've been through many private processes, and three different foreign judgments, you might say, but putting in because of the full safety credit and honoring other court processes, which they have not.
Right.
And then it is a simple one-page claim, which I did fax to you because I made a...
Well, what I'm trying to say is why... Okay, obviously, before Greg jumps in, hang on a second here, Greg. What I'm saying is, where did they get the judgment to take your land, this long title thing that they did to you? What was this title land, whatever you said? Where did they get the judgment that they gives them the capacity now to move on your land and take your land? Where did they get it?
In a justice court through an unlawful detainer, which is a wrong process to, it stylizes us, characterizes us as tenants.
Did you just make a simple one-sentence order to that court, wherever you got, I couldn't really understand the court. Just say that the order there is a void judgment.
I have got this judge. I need to disqualify him. Now he's coming after us for he just issued an order for show cause and possible imposition of sanctions. He's refused my trial by jury, which I paid for. I need to disqualify him. That was going to be my other question.
I'm just going to make up a name of the court because I really couldn't hear what you're saying. I'm just going to say the District Court of St. Louis, Missouri. So this District Court of St. Louis, Missouri, whatever it was, they gave a judgment to the other side to take your whatever they took away. They wanted something from you, so you got a warrant in debt or wrongful detainment or something like that. You got some sort of judgment that you don't believe is accurate.
And I have refuted it, disputed it, all of those things. They still had the sheriff come and throw us out.
Did you file All I'm saying is, did you file a void judgment? Did you just file in that the judgment is void? Just write a simple void judgment claim. Just make a simple claim that the judgment is void. Did you just do a simple void judgment claim?
Not that simple. I did say the claim. I did make a claim recently, and he's saying actually the judge is saying that they're frivolous, and that's why I have got to disqualify.
All you have to do is, like I said, that Richard Cornsforth puts on that great video about void judgments, and he made it very simple and very clear that you could walk into any 99. He basically said 100% of all the summary judgments or judgments that are gotten by an attorney over a man are void on their face because the attorney for the corporation, the attorney for the bank, has no first-hand knowledge and was not allowed to notice the court, motion the court, present evidence to the court, wasn't allowed to do anything in front of the court unless it was a competent witness who had first-hand testimony and could testify under oath of affirmation that they knew what they were moving before the court was true. Now, an attorney can't testify that anything he presented to the court was true for the name of Bank of America or anybody. They can't do it. So, did you ever, I think I probably said this to everybody a million times, did you watch Richard Cornsforth's videos on YouTube?
No, I did not.
Have to watch those. I think it's on the second video. It's 3 videos. I think it's 45 minutes long. It's going to be, I think, around the 50-minute mark on the second. It's like, watched all of them. It's like a 5-minute mark in the second video. The first one is kind of boring a little bit. Richard Cornsforth is a man from Oklahoma. He's a nice man, beautiful voice, nice and lovely, laid-back guy. So it's not a hard video to watch, but he's going to read the whole entire Trinity versus Pagliaro case of 1964. So when you see these 2 other people, a woman and a man, stand up and they read the whole entire case, you can fast forward to it. Just fast forward to that whole thing. 30 minutes of that, just blow right to it, because it's just going to confuse you. And then when Richard comes back and he starts describing what did you people notice in the Supreme Court ruling, in their opinion, in Trinity versus Pagliaro. And everybody in the class says, we have no clue because you bored us to death in 30 minutes reading the whole damn Supreme Court case. So he said, let me make it simple then. No attorney can come forth with unless under oath of affirmation to prove any evidence, produce any documents, show any evidence, show any bills, show anything before this court, motion the court, move the court, ask the court for judgment, unless they have first-hand knowledge that anything on that piece of paper is actually true. Did they produce those? Did they write those numbers out themselves? No. Did they write those? No. They didn't do anything. They didn't do any of those things themselves. So this is where Greg and I try to talk to you folks about this is where you could use the common law to take over their side. And you don't have to go into federal court over this. You just have to go back to the original court, the original jurisdiction who created this judgment against you and just say that it is a void judgment due to what the Supreme Court ruled in Trinity versus Pagliaro. And that's basically it. It's basically a one-sentence thing that you have to say. That no attorney is allowed to present any evidence, come forth unless they have first-hand knowledge, and somehow this court ignored that simple rule. You know why they ignored that simple rule is because you failed to object.
Actually, I did bring this up before, and the judge ignored it. He has, this particular judge,
the judge would ignore it. Judge will ignore it.
I actually, this attorney, no standing or steps here. Where's his authority? He can't speak.
The judge will ignore it if you come in as a defendant.
Okay, so I have to turn around and make the claim. I've done that. I just did this. I did a claim in that court this last week, and he's trying to put it back over on the dead court side as opposed to the common law side, because I've asked for the trial by jury, I've paid for it, and he's essentially refusing it.
You don't need a trial by jury to move a void judgment before the court. You just have to basically say that you moved an error, and if you don't remove this error, it's going to cause me harm, financial loss, damages, and you're going to be held liable. Because I'm throwing your own law back into your face, into your court. Now, Judge, it's a hot potato. What are you going to do with this? Now the law is brought to your attention. Are you going to ignore the simple law? Are you going to ignore the simple facts? Are you just going to throw it all out and just make believe it didn't exist? But like I said to you folks, you've got to be careful Because when you're dealing with a mortgage company or a credit card company like that, you've already established the law in that contract. So you can try to use it intrinsically versus Pagliaro, but the judge will say, no. The rules of the law are established in that contract between you and the credit card company. You reduced your status to act as a pro se. So you're on the level of the attorney for the credit card company. You're all on the same equal playing field right now.
No,
so you got,
I do status to pro se, but no, because I'm
they might not have what you did as status of pro se, but I bet that this whole entire time, when they got the judgment against you, you were always coming in as a defendant.
That is correct, but now I turned around and made the claim, and he's saying these are frivolous, and he's doing this order for show cause and possible imposition of sanctions. So,
what I'm saying is because, like I said, my whole entire lawsuit was shorter than your opening trespass. My whole lawsuit is like, I claim the wrongdoers do a trespass upon my property. That's it, I'm done. That's my lawsuit. I'm done. Your opening, just the opening document on the cover was longer than my whole entire lawsuit. Maybe you listen to the lady from Canada when I said when the state took a province, took her children. I just said, silly name, his name was Jessica something, or Jessica something. And I claim the trespassers do a trespass against my property, upon my property. And that was it. The other side knows what they did wrong. They know that they took the children. They know why they're engaged with Jessica. They know why Jessica is talking to them. It has something to do with children. The bank knows why you're suing them because it has something to do with land or property or something. You don't have to put all this nonsense into your claims and your complaints and your lawsuit. You just say, I claim that Capital One do trespass upon my person. That's your whole entire lawsuit. And I guarantee your lawsuit says a lot more than that. Your title says more than that. Because anything else other than that is frivolous. Nobody needs to hear any of this other nonsense in there. If you want to attach everything else as an exhibit, you just go right ahead and put 9,000 pages of an exhibit in. That's fine. But your lawsuit, your claim better be like one sentence long. That's all they want to see. Everything else is frivolous. You want to make everything else an exhibit? Lovely. But they're not going to take 30 pages, 90 pages, 900 pages of a lawsuit. They're not going to do it.
I do 2-page stuff, so I don't do long stuff.
I guarantee it's just more than one sentence. It's one sentence more too long. It's too long. There's no reason to make it more than one sentence. Are you claiming they did you wrong?
Yes.
That's all you need to say. Everything else attached to an exhibit.
And keep it in the lower justice court. Don't take it to the federal district.
Just take it back to the court of original jurisdiction. Say that judgment is void. It's a void judgment. It's not the judgment is void. It's a void judgment. A void judgment is different than a judgment is void.
It's a void judgment.
Just a void judgment. It isn't a judgment. It's a void judgment. It's like an elephant is a tennis shoe. No, it's not. It's two completely different things. So a void judgment has nothing to do with the judgment is void. It's two completely different things. A void judgment. Right, what was I telling you before that I was saying that one exists and one doesn't exist? Do you remember what I was telling you before? About a void contract or some sort of contract?
Well, it's a matter of, we talked about this 2 or 3 calls back about, the modifying word and the primary word. Okay? And a void judgment is saying that it's a void judgment. Alright? Judgment is void. Implies that, imagine this, the judgment is. Okay? Let's get rid of the word void. The first part of your sentence is the judgment is. That is the statement that says that it exists. And then the word is how it exists as void. Okay? Void judgment is saying that it's void. It doesn't exist. But you put the word is in there, it gives it life.
Oh.
Alright?
So you don't say it's a void judgment because that's saying it is a void judgment. So how do you word it?
Just say a void judgment.
a void judgment?
Because if you say the judgment is void, if you subtract the word void, you just said the judgment is. You just recognize it.
So you're basically saying there is no judgment, because that judgment couldn't possibly exist, because it couldn't have existed based upon the way it was allegedly created. Because an attorney brought it to life, an attorney can't do that.
Right. So you have to avoid any word of acknowledgement of existence, which the verb is provides.
Okay, well, I thought that Karl said to say it's a void judgment, which is, it is a void judgment. So that's not the right one-sentence claim. So, is that correct, or did I hear that wrong?
Right. It is a void judgment altogether.
Okay. It is a void judgment. Okay, I thought that's what I heard.
Not the judgment is void.
I gotcha. Okay, the void has to describe the judgment.
Right.
Oh, that's...
well, kind of. The judgment does not exist. So the judgment doesn't even exist. You describe a judgment that doesn't even exist as a void judgment. It's saying what you think is...
If you want to be cute, you can say, it is a void judgment ab initio.
Okay.
From the beginning.
Don't go Latin. Don't go Latin on them, man, because they can...
Okay, just use plain English.
Right.
It's a void judgment from the beginning.
Yeah.
From the beginning. Okay.
Well, say from the date that it was, the date that it was created, the date that it was issued, April 1st, whatever. There's been a void judgment, controlling this case, so that a void judgment is attempting to control this case. So there's a void judgment interfering with my rights. So there's a void judgment interfering with my property.